Hello, everyone, and welcome to this celebration of Sam Buell and discussion of his new book, Capital Crimes, Business Crime and Punishment in America's Corporate Age, published by Norton Press. I'm Melanie Dunshee. I'm the Assistant Dean for Library Services, and it is my pleasure to quickly introduce my colleagues who probably need no introduction, but I'm going to just briefly introduce them before they talk. The Goodson Library supports our faculty in many ways in creating scholarship and making it widely available. And so we are especially pleased to organize these events to celebrate and learn more about our faculty-authored monographs. And thanks to Senior Associate Dean Guy Charles for suggesting and encouraging this endeavor. So we're all really glad to be able to do this. Professor Sam Buell's research and teaching focuses on criminal law and the regulatory state, and he is frequently invited to speak on these topics in the U.S. and internationally. His recent scholarship explores the conceptual structure of white-collar crimes, behaviors that evolve to avoid legal control, the treatment of the corporation and white-collar offender in the criminal justice system. Professor Buell brings a wealth of both deep practical experience and scholarly insight to these issues. He worked as a federal prosecutor in numerous complex cases of racketeering and organized crime. He's well known also as a lead prosecutor for the DOJ Enron Task Force and a two-time recipient of the Attorney General's Award for Exceptional Service, the DOJ's highest honor. Sam joined the faculty at Duke Law in 2010 after serving as an associate professor at Washington University School of Law in St. Louis and a visiting assistant professor at the University of Texas School of Law. In conversation with Professor Buell today is Professor Barak Richman. Professor Richman joined the Duke Law faculty in 2003 and is a prolific scholar and much sought out and generous colleague. Thus, he is going to be in conversation today. Professor Richman was awarded the Duke Law School's Blueprint Award in 2005 and was named Teacher of the Year in 2010. His primary research interests include the economics of contracting, institutional economics, antitrust, and healthcare policy. His recent work challenging illegal practices by rabbinical associations was featured in the New York Times. And he also has a forthcoming book, Stateless Commerce, Diamond Dealers, Ethnic Trading Networks, and the Persistence of Relational Exchange from Harvard University Press. So soon you will find him on the other side of the table being interviewed as well. So I turn the program over to Sam and Barak. Thank you.
Great. So Melanie, thanks very much for this forum. Thanks very much for the ongoing support you give to the faculty. Sam's work, my work, would not be possible, would not be the same without everybody's support. But every now and then we actually finish something. Congratulations.
Thanks.
This is a huge deal. This is a really big accomplishment.
Thank you.
So Melanie kind of stole a little bit of my early thunder. I was going to ask you to talk about your time in the DOJ, to talk about the experiences, and you might say the relevant life experiences that led you to want to focus on white-collar crime.
Well, that's a nice softball. So thanks, Barak, for agreeing to do this. As someone who thinks a lot about economic institutions, I thought you would be but doesn't think that much about the criminal law most of the time. I thought you would be a great point of intervention to this project. So I'm looking forward to talking to you about it. And thanks, Guy, for organizing these events, which is a great thing. It's a little bit embarrassing, but every once in a while, your colleagues are entitled to embarrass you. Maybe more than once in a while. And I also wanted to make a public service announcement before we go any further, which is this just happens to turn out to be Corporate Crime Day at the law school. I don't know why, but accidentally so. At 5:15 in this room today, we're going to have a screening of The Big Short, which is organized by our Capital Markets Center. And after the screening, there's going to be a panel discussion with Professors Baxter and Schwartz and also me. So it's Corporate Crime Day, and we're serving beer and wine tonight, I think. So lunch and then cocktails.
And then insider trading.
Yeah. So, I guess I spent most of my career as a prosecutor not working on white-collar crime. And I remember being asked by Zach Carter, who's the U.S. attorney in Brooklyn when I was hired, in my final interview for that first job with DOJ, the U.S. attorney has a discretionary docket. What do you think, U.S. attorneys should be doing? What should they be prioritizing? And I immediately said white-collar crime and public corruption. These are complex matters that involve well-resourced actors who are sophisticated, who, takes extra legal tools to respond to, and that's what the federal resources ought to really be used for. And then when I got into the office, there were a lot of people getting murdered in New York City. This was 1994. The murder rate was at its peak, 7 times what it is today, which is unbelievable. Unbelievable that it was 7 times, and unbelievable that it's gone down that much. And there was a unit in the office which Zach Carter had formed to basically use the federal RICO statute, which had been designed to get at the mob, to back in the 60s and 70s, to try to make a dent in the gang murder problem in New York City. And I think we actually did make a significant dent. And we weren't the only office in New York that was doing that, using the RICO statute to prosecute, violent gangs. And I just got immediately drawn into that work because I felt like we were actually potentially saving lives, and that seemed much more real to me than white-collar crime. And so I sort of didn't, that kind of got put aside. And then it really just the way that, a lot of the students will find in their careers that things just happen a little bit randomly sometimes. And the person who had been my supervisor and mentor when I was doing those gang cases in New York, a lawyer who I admire more than just about any lawyer in America, she, through a long career path of her own, ended up getting the Enron case, 10 years later. And she called me up, and at that time I was working as a prosecutor in Boston, working on the Bulger case. And she said, do you want to come work on this with me? And at the time it was the biggest story in the United States. And it looked early in the case like it wasn't just going to be a corporate fraud case. It was going to be also a corruption case. There were allegations of, misconduct in Washington in connection with this company. I remember the day after the day I got her call, the former COO of the company was found having shot himself dead in his Mercedes in River Oaks in Houston. And, it was sort of like, it was like the guy knew too much or something, it looked like that. And so it was a very exciting opportunity. And then I think what happened, surprisingly to me, and partly because of the contrast of the work that I had done beforehand, was as I got really deep into the Enron case, and I spent those 2 years on this really complex accounting fraud and learning all the securities laws that were associated with that, I thought, wow, this is really interesting because it's completely different from street crime. It's very ambiguous where the line falls between right and wrong, and in some sense, in litigating the Enron case, we were deciding in the first instance what was a crime. And that seemed fascinating to me, and even though I've always loved the criminal law and made it my focus in law school and in my practice, I realized that the white-collar criminal law was really that area. I remember when I was interviewing for law professor positions, when I was on the entry-level market, I interviewed at UVA, and I end up in the dean's office, and at the time it was John Jeffries, who's one of the giants of criminal law. He said to me, so you want to do criminal law? I said, yeah. He said, well, there's really not much more to say about it. Since the model penal code, we've kind of worked everything out, and so I don't know, there's not a lot to write about. And I said, well, white-collar crime actually is pretty unsettled. There's a whole lot of theorizing to be done on this, and I'm really excited about it. I didn't get the job at UVA, but that's okay. So better for me, because I ended up at Duke. And then that's what, so it was pretty clear to me when I went into the academy, I knew I would obviously be someone who would teach and write about criminal law, but that white-collar crime and corporate crime would be the place where I could just sort of endlessly mine for difficult problems that don't necessarily have easy solutions, but that's kind of what we like as professors, right? That's where we make our money.
That's where we make our mark,
Yeah, yeah, right. Well, we do get paid for it, but yeah, not by the idea.
When you were working on the Enron case, would you have answered the question the same way that you had before you started working in New York? That is, where we think the Department of Justice should invest its resources?
Yeah, I think so. I mean, I think we talk a lot about the rule of law as a set of principles that are very much structured around restraints on what the state is allowed to do. But, there's also a part of the rule of law that's the minimum what the state must do for us. And the more complex the wrongdoing, the more it threatens to end up basically beyond legal control because it's too opaque, it's too complicated for the legal system to handle. So you've got to have somewhere in the institutions of enforcement, you've got to have a structure that's available that has the kinds of lawyers and investigators and the resources that are available and the time, really, more than anything, to devote, where everything can just be put aside for, it was 4 years from the start of the investigation, a little more than 4 years from the start of the investigation to the trials. And we had turnover, during that process. But there was a task force of people that was their only job for 4 years, was to figure out Enron. And partly because it's just not an acceptable, answer for the rule of law to say, this stuff is just too hard. So, we're going to we can replace this one really, really hard case with, 1,000 low-level, low-hanging fruit, easy prosecutions. And so we're just going to go do that.
And when we say hard, you're not just talking about hard to come up with the evidence, hard to defeat the army of lawyers that the defense has. You also mean it's really hard to determine what's morally problematic.
Well, and which parts? I mean, a lot of people think of the Enron case, the sort of popular version of it was that it was this whole company that was just complete fraud, a house of cards. And that's actually not the truth of the case. The truth of the case is that there was a company with a very, very cutting edge, very complex, sophisticated corporate finance structure. Probably 30% of which, 100% of which was, in retrospect, destined to destroy the company, right? 30% of which involved violations of the law. The other 70% was stupid and not illegal. And, about 30% of it was, and the trial, the litigation in the case probably, was a fight over whether that 30% was really 20% or it was really 40%, right? Because there was some stuff that was clearly over the line, and then there was stuff that was kind of, arguably over the line. And a lot of it had to do with issues of, the thing about business crime is, especially in a case like Enron, as opposed to like a Madoff case, which is, Madoff's essentially just a dressed-up thief. Is that the things that people are doing every day are normal stuff that they do in those jobs, and so when they're doing it, they're committing a crime really has an awful lot to do with the reason why they're doing it and what they're thinking as they're doing it. And that becomes obviously mental state is the hardest thing for the law to get at in any context as an evidentiary matter. And there's also theoretical questions there about what the mental state is that tips you over the line. Yeah.
So you worked for a long time on both violent crime and financial crimes in the Department of Justice. You move into the academy. And then the way your book describes it is one morning in the spring of 2010, you get an epiphany.
Yeah,
Tell us about the epiphany, and tell us why it was an epiphany.
Well, so spring of 2010, we're still only about a year from the absolute peak of the banking crisis. And we're still very much at the point, the conversation has not yet quite started on, wait a minute, where are the prosecutions? right, which has been the huge topic of the last, I guess I would say, 5 years now, and it doesn't seem to be dying down. Big Short is about that, and it's just came out. So that conversation had not really started yet. And obviously I was thinking, as I do now as an academic, every time one of these big scandals comes down the pike, the first thing I think about is, okay, what is this? Is this a criminal case? What's the theory of prosecution going to be? What went on here? What would be the theories of prosecution if you wanted? And my initial reaction, I think, to, as I began to understand, like many people who didn't really focus on this real estate market while it was going on, I began to understand a little bit about the nature of mortgage-backed securities and the trading markets that were associated with them. I'd already started to think, this is not Enron. This is different. This isn't accounting fraud. This isn't a fraud that runs between insiders in a company and their shareholders, right? This is a fraud that potentially runs between sophisticated parties who are trading with each other in a specialized market, and that's going to create some problems for the prosecutors. But there were other theories floating around, and one of them was that Lehman Brothers, for example, had perhaps been an accounting fraud, a la Enron. That Lehman Brothers, before its collapse, had presented its financial structure or condition in a way that was misleading. And then maybe Dick Fuld, the head of Lehman Brothers, could be proven to have known that or intended it. And then that would look more like an Enron-level case. Well, the bankruptcy examiner in the Lehman bankruptcy proceeding, the judges appoint these examiners to do essentially an investigation in a large bankruptcy, had just issued his report. And out it came, and I started looking at it. And I think because there had been an article written about it, I focused in this massive report on this one transaction called Repo 105, which was essentially a series of transactions in which Lehman had structured some activities with its lenders to basically make something that was, in substance, debt, borrowing, look like operating income. So treat money that was coming in the door as income on the financial statements when, in substance, it was really borrowing, and if it had been treated that way, it would have presented a much clearer picture about how levered Lehman Brothers was. So the idea would be, well, this is a fraud because they're lying about how levered they are. And look what happened. They went bankrupt. I read this, and I couldn't believe how exactly it matched a series of transactions that Enron had been involved in with Chase and Citibank leading up to its bankruptcy, called the prepaid forward transactions, where they essentially had agreed with these investment banks who weren't in the energy industry to sell them a bunch of futures positions in natural gas and electricity contracts and then buy them back X months later at a premium that matched exactly what it would have cost to borrow that amount of money from Citibank or Chase for that amount of time. And then treat that, we sold these forward contracts to the banks. That's operating income. That's not borrowing. And the prepaid forward transactions were a huge part of what collapsed Enron. They were billions of dollars. The rating agencies said afterwards, if we'd known the scale of this thing, it would have completely changed our view of Enron, which, was crocodile tears on their part, in my view. But the thing that was the epiphany was, I knew that we had spent all this time on the prepaid forwards in Enron, and at the end of the day, they weren't in the criminal case. And there was no way they were going in the criminal case because they had lawyer and accountant approvals all over them. So Arthur Anderson, Enron's accountant, had looked at the prepaid forwards, and they'd said, someone could say it walks like a duck, it talks like a duck, it quacks like a duck, it's really debt, but under the accounting rules, you can treat this as operating income. And lawyers had looked at the transactions as well, and they had this kind of, to the mental state question, they would have had a bulletproof defense. You misled everybody with these prepaid forwards. Yeah, but we were told by the best advisors in America that these things were appropriately treated under the rules as operating income, not debt. And so when I saw the Repo 105 thing from Lehman, I thought, well, it's the exact same thing. And the reporting on it was that the exact same story. The auditors had scrubbed it, and they had told Lehman that it was permissible to treat it this way, and lawyers had looked at it. And I thought, there is absolutely no way that they're going to be able to build a criminal case against Dick Fuld. And I just thought, it's the same thing all over again. And if anything, it's been done a little bit more carefully and a little bit better, having learned the lesson from the prior case.
And by a whole industry, not just by one firm.
Yeah, and by a whole industry, not just by one firm. And, this is an example, a prime example of the limitations of what criminal law can accomplish in this space.
That's a funny sentence. It shows what the limitations of criminal law can accomplish. I mean, is that intentionally an oxymoron?
No. I guess what I meant was how limited it is what criminal law can accomplish.
Or what it can accomplish.
I'm not following you.
Is this a good thing? Is Repo 105 a good thing or a bad thing?
Well, I think from a regulatory standpoint, from the standpoint of investors, bad thing, right? But the solution to it is to regulate it, right? Is to have a better, a better regime of accounting regulation that doesn't allow companies to treat things that are in substance a borrowing as not, so that they can basically hide from outsiders how levered they are. That's not a good thing, right? But if we can't call it fraud and punish it ex post, then criminal law is not the solution to that, right?
So the book, the way I see the book, there are two key features to this nut of capital offenses, this nut of white-collar crime that you're trying to crack. And one of them you're describing really beautifully, this complexity of how you apply the law, the complexity of how you evaluate certain conduct, even when there's certain conduct that you think is problematic, and even if you think you can identify it, the complexity of how you go about it. You just said that perhaps actually prosecutors are not the right ones. It might be the financial regulators. But there's a whole nother problem that you describe. And this involves corporate misconduct that's unquestionably misconduct. Mm-hmm. And unquestionably, ipso facto, we know a crime has occurred. We're talking about BP. And we're talking about that really horrible story about GM that you opened the book with. Mm-hmm. Maybe tell us the story about GM, and then tell us why, even though it sparks moral outrage universally, it's not so clear what we should be doing about it.
Yeah, so this is a great observation, Barak. I really appreciate that. And it makes me think that the book, you write a book like this, you maybe this is especially true of a first book, but I think probably true of any book that any of us would write. There's still a sense in which it's a work in progress even after you've published the thing, right? I mean, that's true of everything we do, but we're all works in progress.
We're all works in progress.
But I feel like maybe the book hasn't done as good of a job as it could have of putting those two things that you just described together, right? Because I do think they're linked in some important ways. Maybe we can talk about that. So the GM example, some of you have read about the scandal involving GM's faulty starter switch in the Saturn Ion and the Chevy Cobalt. So far, it's been established that there have been at least 100, I think, road deaths as a result of this switch malfunctioning, which was basically just an incredibly simple example of bad engineering. It doesn't take any kind of sophisticated understanding to realize what happened, because it involved simply just one of those little metal springs we've all got and all kinds of things we have at home. And they used a spring that was not strong enough in this starter mechanism. And so the spring that's supposed to hold the key in the on position while the car is running could be jostled out of position, wouldn't hold it strongly enough, and the key could be knocked back into the off position if you had, doodads hanging off your keychain. By your knee even. And then what happens is, also because of the way the integration of certain systems in the car was not done very well, so that when it went into the off position, the driver lost power steering, lost power brakes, and also, most importantly, the airbag would not deploy. So when there was a crash, they were usually ended up fatal. So the book opens with the story of this woman, Candace Anderson, who was driving one of these cars in 2004 and went off the road in perfectly good weather conditions outside Dallas one morning, and her fiance was riding in the passenger seat next to her, and they crashed into a tree, and her fiance died. And so here's this woman, she's been in this car accident, her fiance is dead next to her, she obviously is totally traumatized by what's happened to her and her responsibility for it. And then along come the police, and they're looking at the conditions on the road, and they're going, well, there's no skid marks, and the weather was really good, so what explains this? Mind if we take a blood test? And actually, they don't have to ask, right? They're allowed to take a blood test. Take a blood test. She had some Xanax in her system, which it turns out she had taken the night before, and actually there's not really good evidence that it impairs driving when it's not combined with other substances. But in any event, they decided that this was a intoxicated vehicular manslaughter, and they charged her with the homicide of her fiance. And she decided that she had no choice but to plead guilty, and she pled guilty. She was not put in prison, but she was jailed for some time before the prosecution was resolved. She was not put in prison, but she was put on probation for a period of years and had to do hundreds of hours of community service and all this. Well, 10 years later, and it took 10 years, 10 years later, facts finally come out about the GM situation, and it turns out that it wasn't Candace's fault. It was the fault of the GM engineers who designed this switch, and it was the car's fault, and therefore the manufacturer's fault. And so her conviction was expunged. After 10 years as a felon, she gets her conviction expunged, and then she has to, think about the fact that it was the company that killed her fiance, not her. So you want to say, right, GM is guilty of some kind of homicide here, but it's very difficult because of the nature of these massive corporations. It's very difficult to figure out where within the company the responsibility lies. Now, we do have corporate criminal liability in the US system, and it's actually fairly easy to impose. But it's not a terribly satisfying way of getting justice for something like this, because it's not going to, obviously a corporation can't be put in prison. No one's going to go to prison. GM will pay some money. That will be good, I guess. Might have some deterrent effect. Maybe it makes the victim families feel a little bit better. Perhaps there's some restitution to them involved. But GM being GM, we can't fine them so much that it's going to end up really hurting their business, because we're so dependent on them for all those great manufacturing jobs. And the last thing that anybody in Washington ever wants to do is be opposed to any single manufacturing job that exists in the vote-rich Midwest, much less GM, right? The old saying, GM, what's good for GM is good for America. So, is it possible to fine GM enough to actually change the behavior of them and the other car companies without fining them so much that it's going to cause, jobs to be lost? So corporate criminal liability ends up being kind of a frustrating thing. So then if you say, well, what about individual liability? Where within the company could we affix responsibility for this terrible thing? Well, there is a guy, the engineer who designed the switch, who is a pretty bad guy from what we know, at least from the internal investigation report that GM has made public, because it appears that what he did was he realized at some point afterwards that the switch was defective. The spring wasn't good enough. He replaced it with a better spring, and then he did not follow the GM protocol, which requires that every time you make a change in a part, you file a document that records why you made that change and what it was. He did not put the document in, apparently in an effort to, not get in trouble at work for having to admit that he designed a bad switch, right? And then, as a result of not putting the document in, it took GM many, many more years than it otherwise would have to figure out what was going on. The company did a terrible job of investigating this problem. The lawyers lawsuits were getting filed. There was a state trooper in Wisconsin who went out and did his own test on this switch and figured out what the problem was and brought that evidence into a trial in Wisconsin. And still, the lawyers in the in-house counsel's office at GM didn't figure out that these incidents were related because of this switch problem. It took years. And all the while, the senior managers at GM, including the general counsel, but certainly everybody above the general counsel, were not even briefed on this. I mean, they had no idea this was even going on. This company's so huge. They have so much litigation. There are so many accidents all the time, recalls and product problems, et cetera, that it's just not even on their radar screen. And the report paints a damning picture of corporate culture. You know, that GM is known, there were two phrases that they said were used frequently around GM. The GM nod, which is in a meeting, meetings always end with everyone going, yeah, we should do something about that, you know, without ever being said who's actually going to take the front. And then the GM salute, which is this. You know, whatever needs to be done, it's, yeah, that guy and that guy are doing it. And, you know, the reporting chains were clogged. They didn't, you know, information wasn't shared properly. So you want to, in a very real way, you want to say that this whole story is absolutely, plainly, clear as day, management's fault. But that kind of fault doesn't fit anywhere in our criminal law. I mean, every student in this room has either taken criminal law or is taking it now. I guess there are a few who might be taking it in the spring. But, you know, basic principles of criminal law, there's no such thing as, you know, lousy management of a corporation. Now, maybe you could get the guy for the switch, right? But there was no crime of making a bad switch, right? So you'd have to charge him with like negligent homicide. You know, that as he's sitting there in GM working on this switch, he's thinking somebody might die and I don't care, or he should have been thinking that, right? That's a hard case. Even a harder case to establish that somehow the senior managers are guilty of negligent homicide. You know, while I'm sitting there presiding over this company that has bad reporting chains, I'm failing to be aware of a substantial risk that Candace Anderson's fiance is going to get killed in Dallas. So, you know, it's the nature of the institution. And this is one of the main points I'm trying to make in the book, that, you know, I think most people look at corporate crime and they want to think about it as a problem of individual bad actors, you know, and that it's the nature of the institution that makes this exercise so frustrating for so many people.
Before I get to my next question, we got to talk about Wells Fargo, which is exactly the scenario you described. Yeah. And we heard before the Senate exactly the frustration that you described. Is that just theater?
Oh, well, it's definitely theater.
I mean, just theater.
Oh, just theater. I
mean, do we all know that this is...
I wonder, you know, there's Elizabeth Warren, you know, tenured member of the Harvard faculty. I assume she still is. I don't know. Now, she's not a criminal law professor, but, you know, she's there pointing at this guy going, you, sir, should be in jail. Now, either she's forgotten her criminal law or she knows better than that, right? Because if, in fact, Stumpf doesn't know, right, that these thousands of employees are cramming these products down on the customers that they don't want, he's guilty of a horrible management failure, but not under any conventional theory of criminal liability, a crime. And that is very frustrating. But one of the points I'm trying to make in the book is it doesn't help to just sort of yell in this circumstance and say, you know, that guy should be in jail, because it suggests that, well, the reason that that person's not in jail is there's just some actor in the legal system who's failing to pull the trigger. There's a readily available trigger, and it's just, what, somebody's not pulling it. You know, pull the trigger on this guy. When really what we need to be doing is having a conversation about how do we prevent these kinds of things from happening with mechanisms that exist outside the criminal law is one conversation, right? Another conversation is, do we want a different criminal law? But if we want a different criminal law, then we got to have that kind of a conversation, which isn't a conversation about what to do with Stumpf or what to do with Dick Fuld or the people at General Motors, because, you know, we have this little thing called the ex post facto clause. You can't just, you know, well, let's make a law that makes them guilty. But maybe in the next case, we want something like that. And then we have to talk about, you know, and this is something we're actually going to be talking about in my class this afternoon. Do we want to relax the rules in some sense that we normally apply for criminal law for corporate managers? Very hard question.
Well, the book seems to, well, it's interesting. So these two passages struck me, and it's exactly on this point. And it's the same page. The two passages are basically making the same argument. The criminal justice system can...
So it's a redundancy. I should have edited that.
Well, two sides of the same coin, you might say. The criminal justice system can continue to try to make criminals out of non-human legal entities while we accept two realities, okay? You said, we can do this if we want to, but there are two factual or functional limitations. First, any form of corporate punishment will be unsatisfying because it can't include imprisonment. And second, most cases will need to be settled to reduce their impact because destroying large corporations, given our dependence on them, can mean shooting ourselves in the foot. I want to ask you about that. I mean, is it your sense that without imprisonment, no one would be happy? Is there a way to satisfy Elizabeth Warren through financial regulations? Maybe financial penalties? Maybe firing?
But we do that. I mean, GM settled with DOJ in a deferred prosecution agreement and agreed to pay $900 million. I mean, the numbers are getting crazy in these settlements. You know, I'm looking at Jim Cox, he knows this. I mean, you know, $10 million used to be a big settlement. And $100 million used to be a never heard of settlement now. Now it's like with these big corporations, if you don't put $1 billion on the table, you know, we're not going to, and it's almost this kind of like marquee value thing where it just keeps getting bid up. You know, so let's make the number a really big number, and that will somehow, you know, and yet we still, even as we're doing that, there seems to be this sentiment that, oh, but it's just a cost of doing business. It's almost like if it doesn't put them out of business, then it's just a cost of doing business. And if it's just a cost of doing business, then there's this view that like, yeah, but it's not really going to change behavior. They're just going to price it in. So I do think that the Elizabeth Warrens of the world want, you know, the reaching for criminal law is because there's a feeling that money just doesn't get it done. And we got to go to the next level. And the next level with a corporation, since you can't put it in prison, is putting it out of business.
Right, so why, which is your second point.
Right.
Why isn't that on the table? I mean,
well, it's my fault because we prosecuted the Arthur Anderson firm in the Enron case, and that became this lesson of, you know, never prosecute a firm all the way down because look what happened at Arthur Anderson. He wasted a bunch of jobs.
I actually would have thought that, you know, finally someone really paid for their wrongdoing, and it's thanks to people like Sam Buell.
That's you know, Barak, it's interesting. I've never heard that said.
This is being recorded, right?
What I hear said is you know, wasteful, wasteful, right? Because this idea that now, of course, there's an irony here. There's all kinds of ironies, and I talk about some of them in the book with respect to, you know, the sort of the divergence between street crime and corporate crime. You know, in street crime, there are horrible collateral consequences that are imposed all the time on innocent bystanders in the form of family members, et cetera. But in corporate crime, we think, you know, there's no justification whatsoever for putting, you know, good old hardworking Americans out of work who had nothing to do with the criminal activity. You know, that's prosecutors mucking with the economy in a way that is a complete, you know, category error. It's just not what they're supposed to be doing.
So I want to make sure we open up for questions, but before we do that, you have this amazing scene where you interview Alan Greenspan. The story is, Enron is about to go down. Ken Lay who, in addition to being CEO of Enron, was a very, very active in the Republican Party, had lots and lots of friends in Washington. And he calls Alan Greenspan, and he says, help. And you're asking Alan Greenspan about this. And Alan Greenspan is very straightforward. He tells you that Lay did call him, and Greenspan is listening to his story, and he's waiting for Lay to come around to make his ask. And then you say, Greenspan knew to a moral certainty, he told us, that Lay called that day hoping the Fed would help to offer Enron, if for no other reason, a sense of obligation for the economy as a whole. Greenspan made no such offer. remaining impassive and letting Lay talk. With that, their call and this Washington minuet came to a close. Okay, this is the great sentence. Enron was permitted to go on collapsing. Greenspan could have had no idea that day, in parentheses, we should hope, that his overall body of work would make it immeasurably harder for successor Ben Bernanke to cut short the frantic calls he received 6 years later. Did Greenspan do the right thing? You're questioning whether you did the right thing.
Oh, that's above my pay grade. That's that's for the Fed.
Know.
That's for the Fed experts. But there's a story to be told, right? That Greenspan had a very significant role in producing the housing bubble, and that the housing bubble, and he knew it,
We're talking about Greenspan as the rescuer. Greenspan, you might say, as the person.
Oh, I think. Did he do the right thing by saying no to Enron?
Yeah.
Oh. Well, yeah. I mean, I think Enron. The Enron wasn't the banks. Enron was a contained disaster. I mean, the thing that's so interesting is at the time, we thought this was the biggest thing that could ever have happened in the capital markets. The 7th largest corporation in the United States evaporated virtually overnight. This was unprecedented in our lifetimes, unprecedented since probably before World War II, right? And maybe even farther back than that. It was viewed as the most cataclysmic thing that you could possibly. It was the 9/11 of the financial markets. It was that thing that you didn't even anticipate happening. That was just devastating, and yet it turned out that it was kind of the canary in the coal mine with respect to what happened in 2008, 2009, where we had a similar problem with a set of interrelated firms, which became a much more systemic problem. And then you had this kind of contagion effect. For whatever reason, there was no worry with Enron about a contagion effect. And the government didn't put Enron out of business. I mean, I guess, the Fed could have saved Enron. But politically,
it kind of sounds like saying that you could have saved Enron, or you could have saved Arthur Andersen.
Well, not really, actually. I mean, that's a misunderstanding. Well, most people think that we just sort of said, screw it, you're getting prosecuted. But the reality is, we tried to settle the case prior to indictment, and they wouldn't take a non-prosecution agreement. There's a theory that the partners were deliberately driving the thing into the ground and then getting ready to run with their books of business. So partnerships are weird as objects of prosecution relative to corporations. So I don't. Greenspan, obviously, if nothing else, incredibly politically savvy guy. And it would have been a disaster for the Bush administration if they had interfered to save Enron. Can you imagine? I mean, he probably would have cost him re-election. Not so with the banks and the systemic crisis of 2008, 2009. I mean, in part because Obama sort of inherited it, and he could say it wasn't his problem, but also because I think people fundamentally understood that there was a contagion effect, that we were all just stuck, and there was no alternative.
I should open it up for other questions. Yeah, Jim.
I'm wondering about going back to the Wells Fargo example. If you don't think the stump got just desserts in the end, that he gave back $41 million, right. He's been shamed, and he's probably going to lose his job. So I wonder about that aspect of a prosecutor's life, of thinking about shining a light on misbehavior. Maybe does produce some effects outside the system through the impact of norms and what those norms do to people who can stand in judgment of people like Stump, the board of directors.
Yeah, I think that's a great point. The investigative process and the leverage that it produces to out facts, but also this is another. Corporate criminal liability, as you know, is not hugely popular in academic circles, especially with law and economics people, but it's viewed as nonsensical and inefficient in many ways. But those who do favor it from a law and economics perspective, I think favor it for the reason that it creates a kind of a leverage that can produce other effects. So one of the leverages that it produces is the one that you describe, which is, look, if the corporation has its back to the wall, then the government is able to say, well, impress us. Show us how serious you are about this. In other words, we're not going to tell you exactly what to do because that's your business, but you impress us. So firing a guy and clawing back his comp are two really good ways to impress the government. And maybe, now, a lot of people would say, yeah, but we shouldn't have this being done informally and have prosecutors be in charge of it. We ought to have rules that say, under the following circumstances, you're going to, the comp's going to get taken away. But I do think the comp issue is an important one.
Ben?
I wanted to ask you about deferred prosecution agreements, actually. Thanks for using the term because I had forgotten it. But I wanted to ask what you thought about that as another tool in the toolbox that prosecutors have to be able to basically restructure corporations in certain ways, and what you think about that as a new power for prosecutors generally.
Well, I think it's really interesting. I mean, we've seen, this is a feature of criminal law in general, I think, especially federal criminal law, is that it tends to operate in this kind of unintended gap-filling way, where if there's a problem, the institutions of the Justice Department tend to figure out a way to get at it, even if it's not something that we've really made a decision as a policy matter or certainly at the legislative level to deal with. So Congress has never had anything to say about deferred prosecution agreements. It's not some, legislative policy that was created. But I think it just sort of arose organically from the government having this incredible lever of corporate criminal liability and realizing, as we've discussed, that there's some sense in which the prosecutor has a larger obligation to the economy, and so we should use corporate criminal liability to deal with the problem of corporate crime, but not in a way that puts people out of work. So, how do we do that? I mean, one of the big problems with corporate criminal liability in our current federal regulatory system is that the regulations and law and statutes are seeded with all these debarment provisions that, make a lot of sense when you think about it. Like, if your defense contractor has been convicted of a felony, you'd rather not have them selling the bulletproof vests to the, we don't want felons selling bulletproof vests to the Defense Department. We don't want felons selling, pharmaceutical products to the VA hospital, et cetera. But these debarment provisions can actually result in putting a company completely out of business. I mean, let's say you're a provider in the healthcare industry, and a felony conviction would debar you from participating in any federal healthcare program. Well, that's probably, most of your business. And so the deferred prosecution agreement arises as a way to kind of try to get the leverage out of corporate criminal liability that does things like some of the things that Jim was talking about, changes in management, reform of internal processes, maybe even compensation reforms and all that, without putting the company out of business by requiring it to take a felony conviction. So that in the deferred prosecution, so people know, the charges get filed, but then they get held in abeyance for a period of time while the company complies with all of these requirements to reform itself, and if it does a good job, the charges are dismissed. So it's a kind of a lawyer's created practical way of getting a result that seems, from a policy standpoint, to be desirable without creating a kind of a damage that people wanted to avoid. The problem is because it arose organically and it has no law, it comes from nowhere in the law, there are a lot of concerns about accountability in it. And, there's a very good paper out by Jennifer Arlen and Marcel Kahn at NYU just a couple of weeks ago that I disagree with a lot of, but is a very good paper about, basically saying, prosecutors don't have the expertise to be managing corporations. And essentially that's what's going on in the DPA context, because they're telling corporations, either explicitly or implicitly, these are the things that you need to do to satisfy the Justice Department. And they often have to do with changes in board of directors procedures and compliance programs and all these things that are supposed to be governed by, mostly Delaware state law, a little bit the securities laws. But I think it's very natural that this happened, in an organic way. And unless Congress is going to come and step in, then, this is the system that we have.
Nikki.
I'm really fascinated in the book about the differences between street level and corporate. In particular, the passage that Barak read, the limitations of the criminal law in the corporate crime context. And that's not really how we think about it, right? In the street context, we just think of it as having sort of deeply pervasive, overreaching. So in some respects, it seems like we really have two different types of criminal law, and the considerations that you were talking about that are taken into account in the corporate crime context, or the institutional considerations, are not taken into account in the street level context. So I wonder if you might, just for a few seconds, expand upon that contrast a little bit more, and the expectations, right? So people ask, well, why aren't people going to jail in one context, and the other, why are so many people going to jail, right? The problem of mass incarceration. So I wonder if you might...
well, I think there's two things in particular that I talk about in the book that go to that at various points. One is we do have to understand that most street crime prosecution has to do with some kind of a product or a market that has been banned completely, right? And so if we're going to take the position that drugs or human trafficking or whatever you want to take as your example, certain forms of violence are categorically illegal, then it actually makes the policing function much more straightforward, right? Whereas in the white-collar context, what we're saying is not you can't sell securities or, you can't sell Baroque derivatives backed by mortgages. It's that you can't do it under certain conditions. You can't do it when it's fraud. And what makes it fraud is a complicated question. And so there's an embedded quality to white-collar crime. Now, street crime is also embedded in a social context, right? But there's also, there's the reality that white-collar crime, the big cases that we most care about, are happening within an institutional context which is very opaque relative to the street, particularly the street in heavily policed, areas of this country. Now, some of that has to do with resources and where resources are allocated, and that's a political question, right? But it's also a little bit hard to imagine, like, let's say we tried to reallocate the resources and we put all the, heavy contingent of patrol officers in Midtown Manhattan. What would they do, right? And let's say we actually changed the constitutional law so that they could go up into the office buildings, not just linger around outside hoping to, I don't know what, catch a traitor snorting cocaine on the street or something, and then roll him against the in the fraud investigation. I mean, what would they look for as they were walking around the aisles of the building, looking over people's shoulders as they're working at their desks? It would be, the crime can't be seen in the same way, and that does have to do with first order questions about how we've decided to define deviance in our society, right? And one of the big arguments in my book is that I just want people to see the extent to which those first order questions have hardwired us into a dependence on corporations and capital markets that makes it actually impossible for us, unless we want to have a completely different kind of society, to treat that space in the same way that we treat other spaces with the criminal law.
Ever one more question, maybe? As long as you both ask questions.
Go ahead, Gabe.
No.
I defer.
I'll take two.
Yeah.
Okay. I was interested in the exchange you had with Jim, actually. And,
Right.
I mean, this is something that's interested me for a long time, and so I just wanted to see if you had further thoughts on it. Is, the notion that with prompting by prosecutors, the marketplace can sort of play a function that you're not able to by sorting out responsibility and punishment is a very appealing one, at least for those of us who like markets, right? Mm-hmm. But I wonder whether, from your perspective, you also worry about the possibility of turning what is perhaps, more of a cultural problem or a systemic problem within a firm into something that is an individual problem for purposes of perhaps trying to appeal to prosecutors, right? You mentioned the engineer, for example. I mean, certainly, we could have done the same with Enron, right? I mean, there's any number of these instances where it could be very convenient, right, to turn what is arguably a much larger problem into an individual problem for purposes of serving up.
My sense is the DOJ is getting better at not being snowed in that way. As they do more and more of these cases, it's impossible not to see the repeating patterns. and to go, this is a systems problem, right? And now what they've done with a lot of fanfare is they've hired this woman from the private sector, who I think used to be at Microsoft, who was a compliance expert at Microsoft. They've hired, I think we were talking about this a while back, they hired with a lot of fanfare this woman in the fraud section to be a internal compliance expert for DOJ. And she's supposed to go around and talk to companies about what DOJ expects from the standpoint of compliance. And then she's also supposed to be the resource within DOJ who tells the prosecutors, like, this is how to think about compliance. This is how to think about systems. So I think in an earlier era, it was true that there was a tendency to try to serve up, you know, a bad apple and say, no problem here. But, you know, the one thing that's very helpful, and unfortunately you have to sort of rely on the good graces of these companies, you know, depending on what they want to do. But when you know, I encourage people to read these things when they come out. When the lawyers actually publish, you know, the company's willing to waive privilege, and they publish the internal investigation report, for example, the one in GM, I mean, you get this, you know, the lawyers are writing these reports in a way that is designed to identify the system's problems. So I think it's also the case that the defense bar, and this is a whole other topic we don't have time for, is this bizarre relationship between the government and the defense bar in this space. The defense bar is playing a really big role in this as well. They've sort of learned how to kind of investigate these problems from a system standpoint and write it up that way.
I mean, you're really describing a whole new wing of the regulatory state.
Yeah, absolutely.
All right, Sam, fantastic. It's called Capital Offenses. I encourage everybody to read it yourself. I only read parts of it.
Well,
I only read a few parts of it.
Buy it. At least buy
it. That's right. Sam, thanks. Congratulations.
Thank you, Barak. Thanks a lot.